Okay, imagine this. You find your absolute dream home. It's unique, it's perfect for you, but then your neighbors tell you the rules have just changed and you can't live there anymore. Well, that's exactly what happened in a fascinating legal battle we're going to break down. A story that pits one very unconventional homeowner against the full power of his homeowners association.
So, that's the big question at the heart of our story today. I mean, seriously, can they do that? It's a situation that thousands of homeowners could face, and the answer, as you'll see, comes down to a really complex clash between state law and a community's own original rulebook.
So let's meet our homeowner, Magnus MacLeod. Now, this isn't just any old house we're talking about. He's in Mogollon Airpark, which is a fly-in community, where people literally have planes and hangars at their homes. MacLeod bought Hangar Tract G, and his plan was to make it his permanent, full-time home, just like he believed others had been doing for years.
And things went south fast. I mean, look at this timeline. He buys the place in February 2017, and just a few months later, the conflict is already brewing. By October of the next year, the HOA passes this new, super restrictive rule, and a year after that, boom, they're in the legal system. This wasn't some slow-burn disagreement. This was a head-on collision course.
So let's first look at this whole thing from the homeowner's point of view. Faced with this new rule, MacLeod didn't just roll over and accept it. No way. He fought back. He filed a legal petition basically saying the entire rule change was illegal from the get-go. So what did this new rule actually do? Well, it was a massive blow. It said that living in a hangar was now only temporary, and it defined temporary as no more than 4 months out of the entire year. For MacLeod, this completely upended his life. It pretty much made his full-time home unlivable. So his argument wasn't just about fairness, it was about legality. And this right here, this is the legal bedrock of his entire case. MacLeod pointed to a very specific Arizona state law. And to put it simply, this law says that if an HOA wants to pass a rule that only affects some of the homeowners but not all of them, you can't just get a simple majority vote. Note, you need 100% unanimous written consent from every single one of the affected owners. So MacLeod's logic was pretty straightforward. He argued that since this new hangar rule didn't apply to the regular houses, only the hangars, it was a change affecting fewer than all properties. And because of that, it needed that 100% unanimous approval from all the hangar owners. And, well, obviously he didn't approve of a rule that was kicking him out of his own home, so he said the whole vote was invalid. But, of course, every story has two sides. The Mogollon Airpark HOA had their own take on things, and they filed their own petition. They weren't just defending their new rule, they went on the offense, accusing MacLeod of being the one violating it. Yeah, the HOA's position was rock solid. They believed they had followed all their own procedures correctly when they passed this amendment. In their eyes, the rule was totally valid, and by continuing to live in his hangar full-time, MacLeod was the one breaking the community's governing rules. Now, the HOA pointed to a totally different authority, not the state law MacLeod was using, but their own original founding document. It's called the Declaration. You can kind of think of it as the community's constitution. And paragraph 27 of that constitution was crystal clear. It said they could change the rules with a written vote from the owners of at least 75% of the lots.
And right here, this is what the entire legal battle boils down to. It's so simple when you see it like this. On one side, you've got the homeowner holding up a state law that demands 100% unanimous approval. On the other side, you've got the HOA pointing to its own founding document that only requires a 75% majority. So, which rule wins? That was the million-dollar question the judge had to answer.
Which brings us to the climax of this whole dispute. After both sides laid out their cases, it was all up to an administrative law judge to figure out which rule was going to prevail here.
So, after reviewing all the petitions and weighing every argument, the legal tug-of-war over the hangar home finally reached its conclusion.
And the verdict? The judge ruled in favor of the homeowners association. The amendment, that very rule that limited MacLeod's ability to live in his home, was declared legally valid.
So why? You're probably wondering why the HOA won, right? Well, the judge decided that the specific rule written down in the community's own declaration, that 75% approval rule, was the correct one to apply. In this legal fight, the community's own constitution basically took precedence over the more general state law that MacLeod had been counting on. This table just lays it all out in black and white. Petition 19, the one from the homeowner saying the rule was invalid, dismissed, thrown out. Meanwhile, Petition 34, the one from the HOA saying MacLeod was violating that rule, affirmed. The judge agreed with them completely. So, what's the big takeaway from all of this?
Well, this case is about so much more than just one guy in an airplane hangar. It's a huge lesson about the power of the documents that govern planned communities and what you're really signing up for when you buy a home in one.
So what can we all learn here? First, an HOA's original declaration is incredibly powerful. Sometimes it can even override a general state law if it's specific enough. That 75% approval rule written in those founding documents was the ultimate authority in this case. And that brings us to the most important point for anyone watching. It is absolutely crucial to read and understand these documents before you buy. They are the contract.
And that really leaves us with a bigger, more philosophical question to chew on, doesn't it? This case perfectly highlights the tension that exists in any planned community. It's this constant push and pull between an individual's right to do what they want with their property and the community's power to set rules for what it thinks is the good of the whole group. It's a fascinating balance, and as this story proves, those lines are often drawn in dusty old documents written long before you ever move in.